You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No.
I'm telling you, like, she thought, like, I could not.
Breaking news from the courtroom. Today we're diving into a case that has it all. Probation violations, mental health struggles, and a defendant who just can't seem to follow the rules. Devon Atkins is back in court facing serious allegations of violating her probation, including the bombshell accusation that she contacted the victim despite strict court orders forbidding it. Will the judge show mercy, or is prison time inevitable? Buckle up, because this courtroom showdown is about to get intense.
That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes, the court would like.
Yep, I think I would.
Welcome to a dramatic trial. From the very first seconds, we will witness a defendant who appears to be uncooperative, ignoring the terms of his probation and even contacting the victim, something the court has strictly forbidden. What will be the consequences of this stubbornness? Stay tuned to see the judge's final verdict.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Cole, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jackson County Adult Probation.
And as an adult probation officer, is it your responsibility to supervise an individual on this court's probation by the name of Devon Atkins?
Yes.
Do you see Ms. Atkins in the courtroom here today?
Yes.
Can you point to her and identify her?
Right here in the blue jumpsuit.
Your amended record reflect Ms. Cole has identified your probationer, Devon Atkins.
Record will so reflect.
And Ms. Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court order?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do. Correct?
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Milton Center in person.
Okay, and describe for the court what a TTM is.
A treatment team.
Okay. In your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact a majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself and the court?
Yes.
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and, and was in violation of her probation order?
Yes.
Did you that with her and inform her, it is important to report if you have something come up, you need to let me know?
Yes.
And did she do that?
No.
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision hours?
Yes.
And to report those to you?
Yes.
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
Yes.
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? Sorry. I'm reading that. No,
I was about to, I know, I was about to,
Well, that is in fact a condition of probation, right? It's also a condition of probation that she is to report to you as her address and so that you know where she is all the time.
Yes.
And if she does not do that, is it impossible for you to locate her?
That is correct.
Did she in fact immediately report to you her current address?
No, she did not.
Anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your updated PSI.
The main thing is her mental health. She refuses to address that. We've made appointments for her with Spinal Tap and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So that part, her grandmother was trying to be there for her because of the mental health difficulties. And that's the main thing that we were trying to get her to address.
okay. In a minute. Mr. Lewis, do you have any questions? Hold on, ma'am. You're going to get an opportunity, okay? Mr. Lewis, do you have any questions of Ms. Cole?
Just briefly, during your supervision as Atkins, were you able to supervise her at points when she was on her medication and not on her medication?
The entire time she has not been on her medication.
So she's been medicated this entire time?
Yes, sir.
Anything else?
Nothing else.
All right. Thank you, Ms. Cole. Any other witnesses with regard to the allegations? So based on the testimony.
Unless I may ask, Ms. Cole, Judge,
Yeah.
and you stated that earlier, Miss Evelyn Thibodeau, I believe that is her grandmother, correct?
Yes, definitely.
Hold on, ma'am.
At some point in time in November of 2024, was Miss Atkins violating the condition the court had imposed that she not to have contact with Miss Thibodeau for Miss Thibodeau's safety?
Yes.
Thank you, Judge.
Any questions about that? About the count? That's count 8 with the
Right.
contact? Okay.
Let's pause here for a moment because this is crucial. What we just witnessed is the probation officer laying out a pattern of noncompliance. Devon Atkins was given clear rules: report to probation, complete community service hours, provide her current address, and most importantly, stay away from a victim. But here's where it gets serious. Folks, not only did she fail to report multiple times in November 2024, but she also maintained contact with the victim, Miss Evelyn Thibodeau. In probation violation cases, judges have significant discretion. They can reinstate probation with new conditions extended, or revoke entirely and send someone to prison. The prosecution is building a case that Devon knew exactly what was required of her and chose not to follow through. The probation officer personally made mental health appointments for her, which she didn't attend. This isn't just about breaking rules. It's about refusing help while potentially endangering the victim. The stakes couldn't be higher right now.
Then at this time, based on the testimony, I am going to find count 1, 2, 3, 6, 7, and 8 true. Again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, ma'am, Judge.
Any additions or corrections to that report?
Nothing from the state, Your Honor, unless Ms. Cole has something to add.
Do you have anything to add that's not already in your report?
No.
So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself for her.
Okay. All right. Argument, Mr. Lewis?
Well, Judge, I think definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services the phenotype inmate tomorrow may have, or any programs that probation deems appropriate for her. I have had conversations with her, and meaningful conversations with her, where she has addressed to me her desire to take advantage of those activities if those available to me. She did understand that she had the safety opportunity that didn't go well, but I don't think the mental health issues were addressed, mainly just substance abuse at that point. I think if we can get a handle on that, or get some work done with her to address the mental health issues, I think she'll do a lot better in this situation.
I mean, it's hard when.
Hold on. Well, it sounds like you had appointments that you missed that Ms. Cole made for you. Did she go to regular Safe P or special? Hold on. So she's already been to special needs Safe P. So that was a whole 6 months plus aftercare of drug and mental health help. So, Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one. How many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems.
Well, you obviously we don't know what you need because you won't even go do the evaluation. That if you haven't been on medication, that would be what?
Evaluation where?
At Spindletop.
That's what I'm telling you. That's not. I don't have that. I'm not a psychopath. That is for.
It's psychopath. Nobody's saying you're a psychopath, but you have.
It's called past program. I'm not a psychopath.
That's not what it's called, and that's not the reason it's called that. Okay, if you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication stabilize and not have the issues that you've been having. I'm going to find that you previously entered your, I'm sorry, Ms. Malfino, did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just a runaround circle.
Okay, this moment right here is absolutely critical, and I need you to understand what just happened. Devon Atkins completely misunderstood the purpose of her mental health appointment. She heard psycho and immediately became defensive, thinking she was being called a psychopath. But that's not what anyone was saying. The appointment was for a psychiatric evaluation, a standard mental health assessment to determine what medication or treatment she might need. This isn't about labeling someone as crazy. It's about getting proper mental health care. The judge is trying to explain this to her, pointing out that if she had just attended the appointment, she would have understood its purpose. Here's the tragedy. Devon has been 100% unmedicated this entire time, according to her probation officer. Her defense attorney is literally pleading for her to get mental health services, acknowledging that her behavior in jail points directly to untreated mental health issues. But Devon keeps refusing, creating this circular pattern where she won't accept help, violates probation, and faces increasingly severe consequences. The frustration in the courtroom is palpable. Everyone, her lawyer, the probation officer, even the prosecutor, seems to recognize she needs help, but she won't take the first step. What would you do if you were the judge in this situation? Let us know in the comments.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as?
I have one more thing to say.
Okay.
She is not giving me the information to follow up with those type of things.
Okay. Well, I don't believe you. Ms. Cole would never say go do something and not tell you where to go or help you get there.
No, she said she did not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health and the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do the things that.
I'm gonna die, so I really didn't have much of a choice.
Okay.
Is my life in jeopardy?
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time, find you guilty. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay, I'm going to find sufficient evidence to find you guilty, and at this time, I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections.
This is the moment everything changes. The judge just dropped a bombshell that completely undermines Devon's defense. She references a competency evaluation from January of this year, meaning just months ago, that found Devon Atkins fully competent to stand trial. She understands the nature of the proceedings, understands what's being asked of her, and according to the judge, is simply choosing not to comply. This is huge because it shifts the narrative from she can't help herself due to mental illness to she's making deliberate choices with full awareness of the consequences. The judge makes it crystal clear. I'm not worried about your community service. I'm worried about your mental health and the fact that you're still contacting the victim. There it is. The victim contact issue resurfaces. This isn't just about missed appointments or paperwork. This is about a serious case involving injury to an elderly individual, and Devon continued to contact that victim despite court orders. The judge says she has to protect society because Devon isn't choosing to do what's necessary. Then comes a warning that should make anyone's blood run cold. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. 5 years in the Texas Department of Corrections is now on the table. The situation has escalated from probation violation to prison sentence in real time.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No,
I'm telling you, like, she thought, like, I could not add up there.
I'm going to hand you the trial court certification that shows this
I would
was
like to speak to a detective.
this was not an agreement, and so you waived your right to
said
appeal. I need you to sign that with
I gave you
her.
hospital papers. I gave her everything.
I'm also
I had
handed
a
you.
doctor's appointment and everything. That's what I'm telling
I've got
you.
5 more years that I could add on to that. You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I went to the hospital and everything.
I'm handing you a
3
written
times.
admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered
I
against.
don't have a gun.
I'm not, just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, man.
Good, then you
I'm
don't.
talking to the wrong person. I'm Devon Atkins. I don't have a gun.
I have to require, I'm that to
I don't
everyone.
know what you're talking about. I don't have a gun.
Good, then you don't have to worry about that. Go back with the bailiff.
Thank you.
Even after receiving a 5-year prison sentence, Devon Atkins continues to talk over the judge, claiming, "I'm not guilty and I did not have a choice." But here's what you need to understand about adjudication hearings. When someone pleads true to probation violations, which Devon did for counts 4 and 5, and when the court finds sufficient evidence for the remaining counts, that's it. The judge warned her multiple times. I've got 5 more years that I could add on to that. If she doesn't stop interrupting, that means the initial 5-year sentence could potentially become 10 years. The judge is trying to complete the standard post-sentencing procedures, including the firearm admonishment, which is required by Texas law for anyone convicted of certain offenses. But Devon keeps misunderstanding, insisting, "I don't have a gun," when the judge is simply fulfilling a legal obligation to inform her that she's now prohibited from possessing firearms or ammunition. The patience of this judge is remarkable. Despite constant interruptions and Devon's refusal to listen, she calmly explains each legal requirement. But the message is clear. The time for negotiation has passed. The sentence has been handed down, and Devon Atkins is going to prison for injury to an elderly individual, her grandmother, who was trying to help her through her mental health difficulties. So, let's break down what we just witnessed in this courtroom. Devon Atkins was on probation for injury to an elderly individual, specifically her own grandmother who was trying to support her through mental health challenges. She violated multiple conditions of her probation, failing to report on required dates in November 2024, not completing or reporting community service hours, refusing to provide her current address, and most seriously, maintaining contact with the victim despite explicit court orders forbidding it. The probation officer personally made mental health appointments for her at Spindletop, which she refused to attend because she misunderstood their purpose, thinking they were for psychopaths when they were actually standard psychiatric evaluations. Her defense attorney advocated for continued probation with mental health services, emphasizing that her unmedicated state was affecting her ability to comply. But the judge, citing a competency evaluation that found Devon fully aware and competent, determined she was making deliberate choices not to follow through with programs designed to help her. The final ruling: guilty of injury to an elderly individual, sentenced to 5 years in the Texas Department of Corrections with credit for time served. This case highlights the tragic intersection of mental health, the justice system, and personal responsibility. When help is offered but refused, when court orders are violated, and when victims' safety is at risk, judges must make difficult decisions to protect society. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments about whether you think the sentence was fair, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We bring you real cases, real drama, and real legal analysis. What's your take? Was 5 years too harsh? Or was the judge right to prioritize public safety? Let us know below.